What if I told you that three justices appointed by Donald Trump himself looked squarely at the central legal question before them and answered with a definitive and unanimous no, not a partial rejection, not a narrow ruling, but a sweeping and unambiguous repudiation of his claim? Legal scholars are already describing the moment as unprecedented in the modern era of constitutional law. This morning, inside the marble columns and historic chamber of the Supreme Court of the United States, something extraordinary unfolded. The nation's highest court released a landmark opinion that constitutional experts are calling one of the most consequential rulings ever issued on the limits of presidential immunity. This was not a divided court. This was not a razor-thin 5-4 split. This was absolute unanimity. In Trump versus United States, the justices confronted a single fundamental question. Does a former president of the United States enjoy total and absolute immunity from criminal prosecution for actions taken while serving in office? Chief Justice John Roberts delivered the court's answer in a meticulously reasoned 43-page opinion, and that answer was unmistakable. The former president does not possess absolute immunity from criminal prosecution. The opinion continued. No provision of the Constitution confers such sweeping immunity. The indictment may proceed. The vote was 9-0. Every justice, conservative and liberal alike, rejected the argument that a former commander-in-chief stands beyond the reach of criminal law. If you want to stay ahead of breaking legal developments like this within the first minute they happen, make sure you subscribe to this channel now so you never miss an update. At 10:17 a.m., just minutes after the decision was posted online, Trump responded on social media, writing that the ruling was completely wrong and insisting that every president has immunity. He called the decision political and accused the justices of corruption. But the court's written word leaves no ambiguity. This ruling dismantles the central pillar of Trump's legal defense strategy. Within the first 2 minutes of this historic development, the legal landscape shifted dramatically. And if you want to receive major constitutional updates within the first 3 minutes of release, subscribe now and turn on notifications so you are always informed first. This decision represents 9 sitting justices declaring in one unified voice that a former president is not above the law. The practical effect is immediate. Federal prosecutors are now cleared to move forward toward trial without the barrier of an immunity claim. Sources familiar with the case indicate that proceedings could advance quickly. To understand how we reached this moment, consider the timeline. On August 1st, 2023, federal prosecutors indicted Trump on charges related to alleged efforts to overturn the 2020 presidential election. The indictment included allegations of conspiracy to defraud the United States, obstruction of an official proceeding, and conspiracy against rights. Trump's attorneys swiftly moved to dismiss, arguing that former presidents possess absolute immunity for official acts. On December 1st, 2023, the district court rejected that claim outright, holding that the Constitution provides no such protection. The judge concluded that alleged efforts to overturn a certified election did not qualify as protected official acts. The D.C. Circuit Court of Appeals unanimously affirmed that decision in February 2024. The Supreme Court agreed to hear the case on an expedited basis, recognizing its constitutional magnitude. Oral arguments were heard in April. Today, the court delivered its answer. Legal analysts reacted swiftly. Former Acting Solicitor General Neil Katyal described the ruling as a complete and total rejection of the immunity claim. Harvard Law professor Lawrence Tribe wrote that the court reaffirmed a foundational democratic principle: no individual is above the law. Special counsel Jack Smith issued a statement welcoming the decision and signaling readiness to proceed expeditiously. Trump's attorney, in contrast, criticized the ruling, but acknowledged that the focus would now shift to defending the case on its merits. The White House responded with a carefully worded statement emphasizing respect for the rule of law and judicial independence. On Capitol Hill, reactions split along partisan lines. Some Republicans supported the court's conclusion, while others warned of potential long-term implications for future presidents. In its opinion, the court distinguished this case from Nixon versus Fitzgerald, the 1982 decision granting sitting presidents immunity from civil damages for official acts. The justices emphasized that Fitzgerald concerned civil liability and a president still in office. Criminal prosecution of a former president, the court explained, presents a fundamentally different question. The opinion acknowledges concerns about politically motivated prosecutions, but concludes that those concerns are addressed through existing constitutional safeguards, grand juries, due process, and the high burden of proof required for conviction. Blanket immunity, the court said, would contradict the principle that law applies equally to all citizens. Procedurally, the case now returns to the district court. A status conference is scheduled to determine a trial date. Prosecutors have indicated they may seek a trial within 60 days. The defense is expected to pursue delay. The judge will ultimately decide the schedule. 3 potential scenarios lie ahead. First, an expedited trial beginning within months. Second, delays pushing proceedings beyond the election cycle. Third, a negotiated resolution, though that appears unlikely given current public statements. What makes this ruling especially significant is its unanimity. Supreme Court decisions on major constitutional questions are often deeply divided. A 9-0 vote signals institutional clarity and strength. Trump's own appointees, Justices Gorsuch, Kavanaugh, and Barrett, joined the opinion. That reality undercuts arguments that the decision was purely partisan. Constitutional scholars note that unanimous rulings carry exceptional precedential weight. They are less vulnerable to reversal and more likely to shape legal doctrine for generations. This decision firmly establishes that former presidents are subject to criminal accountability. As the case proceeds, key indicators will reveal the pace of litigation, the requested trial dates, judicial rulings on scheduling, any additional appeals, and the tenor of public rhetoric. The coming weeks will determine how swiftly this prosecution advances. What is certain tonight is this: the Supreme Court of the United States unanimously rejected the claim that a former president has absolute immunity from criminal prosecution. The path to trial is clear. The legal question that dominated headlines for months has been resolved. The broader implications extend beyond one individual. The court has reaffirmed a constitutional cornerstone, that the rule of law binds everyone, regardless of office once held. The decision stands as a defining statement about accountability in American democracy. This story is far from over. As proceedings continue and a trial date is set, the nation will watch closely. For now, the highest court in the land has spoken with one voice. The vote was 9-0. What if I told you that 3 justices appointed by Donald Trump himself looked straight at the legal argument bearing his name and said unanimously and without hesitation, no, not partially, not conditionally, absolutely not. This morning at 10 a.m., inside the marble chamber of the Supreme Court of the United States, something extraordinary unfolded. In a decision that legal analysts are already calling one of the most consequential rulings on presidential accountability in modern American history, the court delivered a sweeping, unanimous rejection of former President Donald Trump's claim of absolute immunity from criminal prosecution. Within the first minute of this report, let me say this clearly. If you want to receive breaking legal and political developments like this before anyone else, make sure you subscribe to the channel and turn on notifications. The case, Trump v. United States, presented a single defining constitutional question. Does a former president of the United States possess total immunity from criminal prosecution for actions taken while serving in office? Chief Justice John Roberts authored the court's 43-page opinion. The language was measured, deliberate, and unmistakable. The conclusion was direct. A former president does not enjoy absolute immunity from criminal prosecution for conduct alleged to have occurred during his tenure in office. The vote was 9-0. No dissents, no concurring opinions carving out exceptions. Every justice, conservative and liberal alike, joined the ruling. That includes Justices Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, each nominated by Trump himself. If you're just joining us and you value detailed, fact-driven reporting on historic moments like this, subscribe now. Within these first 3 minutes, it's important to understand this decision reshapes the legal landscape not only for Donald Trump, but for every future president. Let's walk through how we got here. On August 1, 2023, federal prosecutors indicted Trump on charges connected to alleged efforts to overturn the 2020 presidential election results. The indictment included conspiracy to defraud the United States, obstruction of an official proceeding, and conspiracy against rights. Trump's legal team responded with a sweeping motion to dismiss. Their argument was bold: that a former president is absolutely immune from criminal prosecution for acts performed while in office. They warned that without such immunity, future presidents would govern under constant threat of political retaliation through criminal charges. On December 1, 2023, the federal district court rejected that claim outright. The judge ruled that the Constitution provides no blanket criminal immunity to former presidents and that the alleged conduct did not qualify for protection even under traditional executive authority principles. Trump appealed. On February 6, 2024, the D.C. Circuit Court of Appeals affirmed the lower court in a unanimous decision. The appellate judges wrote that no historical precedent supports absolute immunity for former presidents facing criminal charges. Trump then petitioned the Supreme Court. On February 28th, the court agreed to hear the case on an expedited schedule. Oral arguments were held April 25th. Observers noted sharp questioning from justices across the ideological spectrum, probing the implications of both granting and denying immunity. Today, May 20th, the ruling arrived. Chief Justice Roberts' opinion distinguished prior cases involving civil immunity for sitting presidents from the present question of criminal liability after leaving office. The court emphasized that while sitting presidents may receive certain protections to ensure the effective functioning of the executive branch, those considerations diminish once a president returns to private life. The opinion acknowledged concerns about politically motivated prosecutions, but concluded that safeguards already exist: grand jury review, prosecutorial discretion, judicial oversight, and the constitutional requirement of proof beyond a reasonable doubt. In essence, the court declared that the rule of law outweighs speculative fears of political misuse. At 10:17 a.m., minutes after the decision was posted online, Trump responded on social media, calling the ruling wrong and political. He argued that every president has immunity and warned that the decision would damage the presidency itself, producing a